I call to order this regular meeting of the Board of Public Works this Tuesday, October 10th of 2023. First on our agenda this evening, we have messages from the board. Do we have any messages from the board this evening?
I would just like to say, in light of Adam's comment about civility, that there is a lot of really tragic, traumatic things happening in the world right now, and I would like everybody to please retain some perspective about what we are discussing tonight and remember what's happening to those around us. Thank you.
Thank you. I would like to welcome our member, Jane Cooper-Smith, who is here with us, joining us this week as a member of the Board of Public Works, and just want to extend my thanks to her for her service. Next up on the agenda is appeals. First item under the agenda for appeals is appeal notice of violation 62038-08-1314 at 530 South Washington. Are we calling staff report first or appeal first?
For the appeals, I think we would turn it over to city legal, or would you like the appellant to go first? Okay, city legal would defer to the appellant. Yep.
All right. We can hear from the appellant now. We will need to go ahead and begin the appellant report now.
Yes, I'm getting my documentation.
Okay. Yeah, you can have a minute more to get your documentation, and then we'll have to begin.
If you may, Madam President, while we're waiting, I would like to just make a general statement on the appeal here and such. I know we have city legal and hand staff and such. It has been talked about with city legal and from Corporation Counsel Beth Kate that we would be willing to have staff from many different city departments meet with Mr. Davis on site and discuss the different materials on site and such. So that offer has been extended and accepted according to emails today from Mr. Davis. So we do plan to still go forward with that when and if possible. We are asking that we do proceed with the items on the agenda this evening, and then, but that is something that we do still plan and fully intend to do.
Thank you. All right, if you can please state your name for our record.
My name is Joseph Davis. I reside at 530 South Washington Street. And I am ready to begin. First, I would like to have Title VI brought up on the monitor.
Joe, that's not how. Please just present your case, okay?
My case depends on the parsing of Title VI and the definitions therein, in which I'm being accused of violations of the section.
Mr. Davis, I will let you know the board does have a copy of Title VI as you emailed.
Well, then I would like it to be pulled up on the screen so we can look at it and parse it.
Mr. Davis,
In
they
its
have,
text,
they have
in its
copies.
entirety.
They have copies in front of them.
This is for the benefit of the general public and those who are in attendance.
We don't have that ability right now. Please proceed.
You do not. Why don't you?
We're working on it. Please.
Then I request that we continue this meeting until it's possible for the general public to benefit from the parsing of this title,
So,
which
Ms.
is,
For the purposes of this appeal, it's coming before the board for review, and so we would ask for you to offer your report on the appeal. We do have Title VI available to us, so we would prefer you proceed with the report.
I ask humbly that we continue this hearing to the proximate meeting in 2 weeks such that the technology can be remedied, and also, too, much of my documentation was not able to be presented that I submitted today.
Mr. Davis, we are going to pull this up. That's normally not how this would work, where you would just come to the meeting and request for specific things to be pulled up on the fly as we go. We're going to accommodate your request with Title VI at this point in time, but in a situation like this, it would have been appropriate for you to ask ahead of time, specifically which documents you would have wanted up. We're going to try to accommodate and do our best here, but we would ask that you just proceed with your appeal.
I'm sorry, I ask that this appeal be moved 2 weeks from now until the technology is available such that, and as well, such that the documentation that I sent to April today for the packet can be submitted and reviewed by the board.
Mr. Davis, every email that you sent today was forwarded to the board up until maybe 18 or 20 minutes ago. I think there were still some emails coming through, but we have submitted everything to the board that you sent along today.
There were also approximately 17 images that I submitted. And are they in the packet?
They do not get, the packet does not get updated like that, Mr. Davis. Please proceed with your appeal.
I ask that this appeal be continued to the next board session in 2 weeks so that I may be appropriately given my rights, my civil rights, to present my materials to not only the board, but to the public at large. Because this is not just a prosecution of me. This is a prosecution that many others will be facing because I have been singled out specifically, unlike any other person in the city of Bloomington.
I hear your request. Thank you. This is the opportunity to make the appeal. In the appeal process, it's simply granted that there will be an opportunity at a meeting for the appellant to offer their appeal. There aren't any guarantees on technology or other items that would be available in support of that appeal other than the appellant making their appeal at a meeting. This is the opportunity to do so. If you don't take that opportunity to do so, it is still under the board's purview to continue consideration of this appeal as it has been presented to us in the packet.
I ask that this appeal be continued to 2 weeks from now until the technology is corrected such that the public can see the full documentation as well as the board have an opportunity to review the many documents that I proffered today throughout the day.
Mr. Davis, are you choosing at this point to not offer the content of your appeal?
No, I am kindly and humbly asking the board to continue this appeal until the next available opportunity in 2 weeks at the proximate Board of Public Works meeting.
Okay. I appreciate your request. I would like to be able to hear staff report from City Legal at this time.
Mr. Davis, can you please vacate the podium and allow city staff to address the board?
So may I ask, why is the staff going to make a presentation if I have made a request humbly that we move this appeal to the proximate Board of Public Works meeting?
If you would allow, I'd like to make a comment, I suppose. Mr. Davis, this has been going on for some time. You're very well aware of that. This has been going on throughout the last year plus, if not 18 months, correct? There have been multiple postponements over the last several weeks of this, and what they were at the city's request, correct? Because we had staff out.
The postponements
Yes.
were
Yes.
at the city's request, and so therefore, I ask for the courtesy
Mr. Davis.
for a postponement for 2 weeks until the proximate.
If I could please finish my comments.
Go right ahead.
Thank you. I understand that this has been postponed on multiple occasions throughout many of the last months. This has been being worked on with you for many, many, many months in terms of information sharing. All of the information you shared with April today was shared with the board. We have passed along all of those emails. We are asking that you provide your appeal and let the board make a decision. They can make a decision later to table this if they're so swayed, but this is the appeal process. This is what we have been working towards for many weeks now. Now is the time to provide your appeal to the board and have them consider it. That is the process. I understand that you wanted things on the screen. We've tried to accommodate you. We put what you wanted on the screen. We would ask that you either present your appeal or allow city staff and city legal to make a presentation.
It would be inappropriate for city legal to make a presentation without me being able to make my full stated case.
Now is that time, sir.
No, my full stated case is is being denied because the technology is not working. The images that I submitted have not been entered into the board packet. I don't even know that all of my emails were entered into the board packet. I got no confirmation.
Mr. Davis, it is not the practice that you get to dictate what gets put into the board packet. We have submitted all of your information that you have provided to the board. We don't just update the packet with every request to put information in. There's other information that was requested to be put into today's packet for other topics that was not included because it is not part of the traditional process of what is provided to the board. That is where we're at. This is your time to allow your appeal. Would you like to take that, or would you please vacate the podium so city legal can make a presentation?
It's not proper for city legal to make a presentation without me being able to present my fullest case in my defense.
As I am presiding over this meeting, I request that City Legal make a presentation.
Thank you, Mr. Davis.
And what is going to happen after city legal taints the waters?
The board will make a decision on this appeal in the next proceeding, but we do need to hear from the City Legal report on this item.
Without me being able to give my full presentation?
Your opportunity was this moment. You are choosing to not use this opportunity.
I am not choosing. I am humbly asking for a continuation of this appeal to the point where you may be fully informed with the information that I have provided.
And I do hear that. And I would like to hear from City Legal on their report in order to consider this item before the board.
But if city legal makes a
Mr. Davis.
presentation without my ability to offer my own defense in its fullest, then the waters will be tainted because city legal is very biased, and they have shown that. You have seen, if you've received the emails that I sent today, forwarded, that there is a bias and a situation where city legal is tendering offers to bring all parties together to discuss what exactly is compliant and non-compliant on my property. I accepted that offer. It's inappropriate for us to proceed in this forum until that takes place, because that is going to bias, whatever you're listening to from city legal is going to bias not only you, but the general public against me.
Okay. We have Corporation Counsel Beth Kate on Zoom who has raised her hand and would like to comment. Could we please allow that?
Yes.
Go ahead, Ms. Kate.
Okay, can you all hear me?
No issues, just a second.
And Beth?
Can you hear me now?
Not very well.
Okay. You know what, why don't I just come down?
Mr. Davis, if you could please vacate the podium.
And to my
You will have every opportunity as you've been afforded throughout this period. I'm asking that you do that so that Beth Kate, Corporation Counsel, can at least address the board as the presiding officer has requested.
And will I be allowed to come back up?
I think we could guarantee, Mr. Davis, that you would be allowed to speak again this evening.
I will call for that opportunity.
We are not trying to prevent you from providing information to the board, Mr. Davis. I promise you that.
But April has already told me that she didn't include all of my presentations into the board packet.
Mr. Davis, we have tried to explain to you that is not how this works. You cannot, throughout the day of the meeting, be requesting and continually requesting additional things, continually be added throughout the day as you did today. Thank you.
I'm
Thank
sorry,
you.
just...
Mr. Davis, I'm asking that you politely vacate the podium. We will stop this portion of the conversation. We have asked Ms. Kate to comment, as the board presiding officer has done. You will have an opportunity to speak again, okay? Thank you.
I have to point out that Assistant Attorney Christopher Wheeler just presented to me only 10 minutes ago some images that were illegally taken of my property just today without notice, and I'm supposed to be able to prepare a defense when I show up here without having an opportunity to review those images? Now, he says this pertains to the abatement appeal, which follows a little later on the agenda. But how is Christopher Wheeler able to introduce evidence to me, discovery to me, just prior to the beginning of this meeting? It seems like everything is building to bring me down at my expense, while city legal and hand hold all the cards. That's why I humbly ask that this appeal be continued to the next Board of Public Works meeting in 2 weeks, and as well, the order of abatement, because the order of abatement is based on the outcome of this notice of violation and fine, which I am first appealing.
I appreciate your request. I do need to hear from Ms. Kate.
Good evening, board members.
I came down so I could address the comments that I think were made by Mr. Davis and also by Mr. Wason earlier about communications that I had had with Mr. Davis. He has asked for a postponement of this proceeding based on my extending an offer to have representatives from HAND. Legal, I suggested to him he talk with someone from the county building department, et cetera. That's all. Planning and transportation as well. That is true, but I also indicated very clearly that these proceedings should go forward, by which I mean this proceeding tonight and the Board of Zoning Appeals hearing that's coming up a little bit later in the month. And specifically because there have been repeated disagreements between Mr. Davis and staff about the way that his materials land under Title VI and Title 20, and this board and the Board of Zoning Appeals will be able to react to his claims if he's going to make that presentation, and staff's, and go ahead and provide the guidance that you can give on these issues. There's no reason to wait. There is every reason to go forward. This has been going on a long time, and I made that very clear to Mr. Davis, as well as the fact that in the future, staff will continue to be available to answer questions about individual materials. They have done so in the past. They will do so in the future. So I'm going to come back possibly down here if I need to, but I heard that and wanted to come down and react to it. So if you have any questions about that, I'm happy to try to answer them.
Thank you.
You're very welcome.
I'm sorry, I have to say, Ms. Cates' tender of getting all parties together to come on site to my property was made prior to this meeting. And it was also accepted by me prior to this meeting. And it's inappropriate to hold a quasi-judicial adjudication forum like this until after this meeting of the minds has taken place.
It is not inappropriate. I'm going to go ahead and jump in. It is not. First, as I said before, I made the offer. I immediately actually deleted that message because I didn't think it had gone out, because I wanted to think further and talk with HAND and planning to better understand all of the communications that had gone before. And also because I realized that that did not make clear that I believe this proceeding and the Board of Zoning Appeals proceeding should go forward. So not having understood that that original message actually went out to Mr. Davis, I was developing a fuller message. He then emailed me accepting the offer, right? Which, again, the offer stands. The offer, though, is an offer to have staff meet with him in the future to be able to deal with any future questions he has about items on his property. I sent another message back making very clear, in response to his to me, that these proceedings should go forward. I disagree that there's any reason to wait, and I urge you to go forward.
Thank you.
Thank you.
I ask that that chain of emails be brought up on the screens for the benefit of yourselves and the public in general, because that is not what Ms. Kate tendered. She tendered an offer to bring all parties together because for over 1 year, 14 months, I have been requesting clarification from Planning and Transportation and from HAND to point out specifically what is or is not in violation of Title VI, the Sanitation Code, and Titles 20 of the Bloomington Municipal Code. I have sent voicemails, I have sent emails, I have sent certified letters. I have been met with no response whatsoever. I have reached out to other city employees to see if they could be a liaison for communication with HAND and Planning and Transportation. And they have told me either that their hands are tied because they've been told by the managers of their department, be it John Hamilton in the executive branch, or be it Scott Robinson, the head of Planning and Transportation, or I don't know. Obviously, John Zodi, the head of HAND, has been telling people not to communicate with me. Back in when the city proposed to abate my property on the 26th and 7th of June, then I spoke with Assistant City Attorney Christopher Wheeler after John Hewitt, or not John Hewitt, but after Rob Council and another staff member, compliance staff member, came and served me with an order of abatement that was going to commence within 1 week. And I asked specifically why no one had reached out to me and communicated with me when I had made multiple requests for clarification. And Rob Council told me that Assistant Attorney Christopher Wheeler had told them not to speak with me. Well, I called Christopher Wheeler within the next day or so, and I asked him specifically, did you tell members of HAND or any other department not to communicate with me? And he said, absolutely not. And some of the documentation that I submitted tonight was a letter that I wrote to Court 6 Judge Crothy, who was the judge overseeing my lawsuit against the city, in which I was trying to find justice under these issues, where my rights to due process have been repeatedly denied. Even Ms. Karen, back on the second appeal of last year, when I came before the Board of Public Works at the close of that, she said, could someone please present Mr. Davis with a specific list of the items that are not compliant? And lo and behold, just this past Thursday, Christopher Wheeler submitted 15 images and a very general description of the items that are not compliant. So, Ms. Karen, you made this request probably, I would say maybe 8 to 10 months ago. And finally, just 2 business days before this hearing, I'm presented with discovery, with evidence, and a very general description of what is not compliant? What is going on? Why are my rights to due process being denied? Why is it that tonight Ms. Kate is not telling the truth about her emails? Her tendered offer did not include any such thing that stated that it was best to go forward with the proceedings tonight. What she tendered was an offer that she would organize all parties involved. We would meet on site at my property. We would hash out whatever items might not be in compliance and which items are, and we would set hard deadlines for me to achieve compliance, hard, reasonable deadlines for me to achieve compliance. I responded 2 days later accepting that offer, and I suggested that it's best that we continue this meeting tonight. My appeals for the notice of violation and fine, and my appeal for the request for abatement, which is all based on the notice of violation and fine, until the proximate hearing date. I also requested that we move the BZA appeal, in which I'm going before the Board of Zoning Appeals under the Planning and Transportation notices of violation, that be continued until next month, because there's a point in time in which if a person is making appeal, before the BZA, they have to publish that in the HT. And that was published yesterday. So I suggested that we best to postpone that and continue it till next month, such that the taxpayers' money was not wasted on an unnecessary ad. And she, the next day, responded that she was surprised that I got this email when she had sent it twice. She sent it to me twice. Her offered tender. And I responded affirmatively that I thought it was a good idea and that we should make this happen.
Mr. Davis, if you would allow me, can I interrupt, please? Would you allow me to make a statement? And I would like the board to hear what I would like to offer and see if we can make some progress here. It has been very clear. City staff, Ms. Kate and others have offered to meet Mr. Davis on site. Absolutely. It was our intent to continue with this meeting. We have for over a year now found that his property has been out of compliance with Title VI and Title 20. There have been court orders that have said that the courts agreed with our position that you're, so please let me finish. What I would like to offer is that we are going to ask the board to continue and take action tonight on this, but that we will guarantee you those meetings on site where we will look with you at each item that you want to go over, but it needs to be in a good faith effort, and we will not order the abatement until that occurs. But we do ask that this board continue with the work that they've been asked to do on this evening, and that would be what we would offer, is that that abatement will not occur until staff meets you on site. We will not move forward with anything until that occurs.
I'm sorry, Mr. Wason just stated that the court recognized that the possessions on my property, my sanctioned building materials and tools, for which I have a building permit from the Monroe County's building department and a certificate.
I want to stop for just a second because I believe what you're speaking about right now is Title 20, which is not what we're here to discuss at this
Okay.
moment. So I do want to take a moment, though, to recognize another board member. Did you have a question that you wanted to ask before we proceed?
I did. I really just wanted to acknowledge my role as the newbie and say that it was really important to me to be able to hear you talk us through your appeal, Mr. Davis. And so I wanted to encourage you to do that, which you have started doing. So it's really helpful for me to have the kind of start to finish context from you. And I have read through the bulk of the material that was sent. Unfortunately, the court case came in later, but a lot of my questions had to do with that. And so I think if we continue the proceeding, I'll have the chance to ask a lot of questions, and I'm a good proxy for the public because I lack the context of the previous discussions that you have had with the Board of Public Works and with staff members. So,
I'd like the opportunity for city legal to clarify if I misspoke on what occurred in the courts. I want to make sure that is in the record appropriately. Can you allow city legal to do that quickly?
I can equivocally say that the reason that my lawsuit was tossed out was based on a technicality on my original complaint. It had nothing to do with the merits of my case, in which I was never able to have my day in court. I was able to convince the judge that I would suffer irreparable harm if my building materials and tools were taken from me, which Hand has described as garbage scattered indiscriminately across my property. Just because they say my building materials, my organized and well-maintained tools are garbage does not make it so. So my lawsuit is pertinent to this issue. Planning and Transportation has issued notices of violation for illegal outdoor storage, but they are, I have sanctioned, I have a building permit.
I'm going to have to remind you that this is not related to Title 20, and at this time, I would like to hear from City Legal.
My building materials and tools being
I would
called
like
garbage.
to politely ask
does-
you to please allow City Legal to make their presentation at this time.
If City Legal makes a presentation and poisons the waters when Ms. Coopersmith has just stated that she hasn't been able to review all of the materials that I presented, then this is not providing me with the due process
We have
that
offered
is
40
necessary
minutes-
for a
40
fair
minutes.
hearing.
We have offered 40 minutes of due process. I would like to request that city legal make their presentation at this time.
I need to ask you to vacate that podium, please. At this time, without further comment, we need to allow the board officer to manage the meeting. I am asking that you please vacate and do as she has asked to allow city legal to make some presentation here. Please.
And what will happen? Will we
Davis,
postpone
we are not-
this?
we cannot
such that
continue.
All of my presented documentation will be available to not only the board members, but also to the general public? I'm being tried in the general public.
Mr. Davis,
in
right
this
now is the
forum.
time that we would really like you to vacate this podium and allow city legal to do what the presiding officer has asked. Please do so now.
And that
Mr.
is,
Davis.
that is just a clarification that, that Mr. Wheeler, Assistant Attorney Wheeler, is going to clarify that my case was not tossed out due to the merits, it was tossed out on a technicality.
In order for us to proceed, we do need to ask city legal to make their statements, and we do need to have you vacate the podium.
But if I'm
I
not
am
given an
requesting-
opportunity
I
to
am
present my fullest
requesting-
case, then this is a poisoning of the waters against me.
I do not want to have to take any further steps of asking BPD to come here or anything else. Please allow the presiding officer to do what she has asked and allow city legal to present.
Again, I ask for a postponement, a continuation of this hearing to 2 weeks from now, such that yourselves can review everything that I submitted, including the images, including the documentation that I sent from the court case, as well as the general public to get the fullest picture and not just a slice which is biased against me. I humbly ask you, please, let's continue this appeal and the subsequent abatement appeal until the next meeting. If city legal presents erroneous evidence against me,
Madam President, can I ask that you temporarily adjourn this meeting?
Okay. Can I take a recess?
Take a recess.
I would like to call a recess.
Thank you.
I'm calling our meeting back from recess, this regular meeting of the Board of Public Works, this Tuesday, October 10th of 2023. I have requested Mr. Chris Wheeler to please proceed with his report.
Good evening, this is Chris Wheeler. I'm an Assistant City Attorney with the Legal Department for the City of Bloomington. This evening before this board, we have an appeal filed by Mr. Davis on a violation that was issued by hand for a property that is owned by Mr. Davis, as he has stated from the podium. He is the owner of the real estate in question. The NOV was issued on 8/17/23, and I'd like to present that notice of violation to the board for review. I believe that was in the packet, but I present a copy for you just the same. I have present this evening with us Mr. Rob Council, who was the officer, the compliance officer, who issued the NOV. And if Mr. Council could approach the podium.
Mr. Davis, we need to have access to that podium, please.
why are we moving
Okay,
forward
then
with
I'll
this
have,
appeal?
I'll have Mr. Council come over here and just speak over my shoulder. It would be my pleasure to have him do that.
Hi, Board. I'm Rob Council, Compliance Officer with the City of Bloomington Housing and Neighborhood Development Department.
Members, now these photographs were taken, Mr. Council, I just handed a packet to the board. You have that same packet in front of you. Mr. Mr. Davis has the same packet in front of him. The photographs that are in this packet that have been handed to the board for review, were those taken by you and Mr. John Hewitt?
That's correct, sir.
And can you tell me, when did you take those photographs?
These photographs, are these today's photographs?
These are the first 15 photographs that were taken.
I took these photographs the morning of our canceled hearing, the last Board of Public Works. So it'd be that Tuesday morning of our last Public Works meeting.
And when you took those photographs, were you on Mr. Davis's property?
No, not at all.
Were you on the neighbor's property?
Yes, I have permission to cross both neighbors to the north and south's property from the property owners. Most of these photos were taken either from the alleyway, the right-of-way on the street, or from the neighboring properties.
And on the day that you issued the notice of violation back on August 17th, you had an opportunity then to view Mr. Davis's property?
That is correct?
The condition of the property at the time that you viewed it and issued the NOV, was that condition the same as what is reflected in the 15 photographs that have been presented to the board?
Yes, sir, it is.
And the exhibit list, as it shows kind of as a schedule on the front, these descriptions are arrived at by you for the board to understand what the nature of the violations on the property are. Is that right?
That is correct.
And what Hand believes and what we believe is that there are items of garbage on the property.
Yes, yes,
More
sir.
particularly, I think rubbish. Is that correct?
That's correct, sir. All violations of Title VI.
All right. Thank you very much. That's all I have for you, Mr. Counsel. If the board has questions for you.
Questions from the board?
Yeah, thanks for the presentation. So the photos in this packet are different than what's in the board packet that was circulated?
Not at all.
Okay, thanks.
The original
I'm not
board-
done with my presentation. I just wondered if the board might have questions for Mr. Counsel.
Are there other questions for Mr. Wheeler or Mr. Counsel?
I will state that you'll notice there is then a separate section at the back with an additional 4 photographs which were taken today. Those I will be addressing with the board during the abatement hearing, if we're going to have that abatement hearing this evening. I will say this for the benefit of our new board member and for the board. The NOV that was issued is for deposit of garbage. You heard Mr. Davis categorize what the city believes as a random scattering of garbage on his property, and that is not at all what the city believes. What the city believes is that there has been a deposit of garbage, and if you review the Bloomington Municipal Code at 6.06.020, you will find that it is unlawful for any person to throw, place, or scatter. So scatter is in there. Throw or place is also in the code. We believe that Mr. Davis has placed garbage, possibly recyclable materials, maybe yard waste, but definitely garbage, on his own premises. He has suffered and allowed for that to continue, and the NOV is issued as a result of that. The provisions shall not restrict the filling of lowlands. We don't believe that's going on. We just believe that he has garbage on his property, and it's not an issue in the Bloomington Municipal Code to discuss whether that person has any intent to later remove, cover, or burn said garbage. It's just a fact that the garbage is on the property, and that's what makes it a violation, and that is why the NOV was issued. The Hand Department believes that the board should deny Mr. Davis's appeal and uphold the notice of violation as issued. Now, I will say one last thing. If the board, upon review of these photographs, believes that the items viewed in these photographs are in fact all building materials, as Mr. Davis would like the board to believe, then Hand won't remove any of those items, and you should uphold his appeal and find that there is no violation. The question of proper storage of building materials, if any of those items are in fact building materials, will be heard on Thursday, October 19th, 2023, at the Board of Zoning Appeals. I apologize, I have one more thing to say. Mr. Davis brought up a question or made a comment about how things arrived and resolved as a matter of the administrative review request that Mr. Davis filed in the trial court. Mr. Davis sought an administrative review of this board's findings with regards to NOVs and abatements in the past. In that proceeding, Mr. Davis is correct. The trial court determined that there wasn't an issue of fact in front of the board. I spent a lot of time in private practice, and it took me a long time to learn not to say court or judge to this board, and now I find that I'm having a hard time reverting back when I'm talking about the trial court. But the trial court, during those proceedings, determined that there wasn't an issue in front of the court. The court did not have jurisdiction because Mr. Davis's complaint was deficient, and it dismissed the case. There was not any review of this board's decisions. So to some degree, I agree with Mr. Davis. I don't agree that it was a technicality. I agree that Mr. Davis's complaint was deficient in that it didn't state anything that the court could review and either approve or deny. He has appealed that decision, and it's on appeal at the moment to the appellate courts in the state of Indiana. And now I believe I've said everything that I would like to say. If there are any questions from the board, I'd be happy to try and answer them.
Questions from the board?
I assume we all have questions, so I'll just jump in. So given the context of the previous notices of violation and the prior court case, and I guess which is ongoing, today we're considering the 8/17/23 notice of violation and what happens relating.
That's the only issue before this board.
Yeah.
Anything that may have occurred predating, it could be information that the board might find interesting, but it certainly doesn't say anything about whether there was a violation occurring on the 17th of August when that NOV was issued.
I also have a question about the total amount of the fine that, my computer keeps shutting down.
The
That
amount of the fine is $50
Total?
total.
And what would be the range of fees that Mr. Davis might accrue?
The schedule is such that the first NOV in a 12-month period is $50. If there is a second subsequent in that same 12 months, it's $100. If there is a third one, it's $150, and that's as high as it goes. Any additional fines in that time frame would still be at $150.
I'm going to keep going unless you tell me not to. Okay. For me, I have similar questions to what I think Mr. Davis has had about the definitions in the code, and it sounds like forward progress is potentially being made between the two parties in kind of distilling what some of that might
I can
mean.
read those definitions
It's
that I
okay,
think are
I've read
pertinent.
it many times
Okay.
at this point. What would an agreement look like that would govern how legal Board of Public Works, legal hand and planning might proceed with Mr. Davis? Like how, there's a verbal agreement that's in place. It seems like you're amenable to the way that's been described, Mr. Davis, somewhat.
I'm amenable to my accepted offer, yes. I'm not
Yeah.
amenable to the email that was sent to me the following day, pulling back that accepted offer.
Oh, okay.
Yes, I was not involved in any negotiation of this agreement. Corporate counsel Beth Kate is involved in that discussion with Mr. Davis. I can tell you that when Elizabeth Karen suggested that somebody might go down to Mr. Davis's property to help him identify items that are in violation, they were abused by Mr. Davis, and Mr. Davis refused to allow them to do their job to help him identify the things that were in violation. So, having said that, I would like this board to know that the city does still wish to amicably resolve these issues, and if Mr. Davis would in good faith actually discuss the nature of the violations on his property and come to a manner that would be successful in resolving these issues, I think that everybody would be very happy with that. To that extent, I'm allowing corporate counsel who initiated these discussions with Mr. Davis to continue those discussions with Mr. Davis.
Thanks for that explanation. I think,
Can I just ask a
Yeah.
follow-up question about that, please? Mr. Davis, you refer to an email, a secondary email from Ms. Kate that pulled back. Is Ms. Kate by chance still on the line and might speak to that? She's not, okay.
I forwarded that string of emails to April to include in the board packet for tonight.
Beth is on Zoom, so she's able to.
Hey, can you all hear me now?
Just one moment, we're adjusting volume.
Try again, Beth.
Can you hear me?
Yes.
Should I just come down again?
We can hear you.
Okay, sorry, I thought I heard that there was a question about the email exchange, and I raised my hand to try to answer that, so.
Do you want to ask the question one more time?
Sure. Mr. Davis referred to an email the day after the original email pulling back the offer from Mr. Davis's point of view. I'm wondering, Ms. Kate, if you would please explain from your point of view what was in that second day's email.
Do you know what, I am going to come down because I can't hear you very well. So I'll be down in a minute.
Clarification. On Friday of last week, I sent an email to, or actually it was Friday of last week. I sent an email to Ms. Kate at the behest of Adam Wason to ask what the results might be if I were to pay that $50 fine. Would it make the would that satisfy the notice of violation and make the abatement go away? Not that I agree to the accusation that my building materials and tools are scattered garbage, but just to make it go away. I would pay $50. And she responded back, no, the $50 fine has to be addressed, but I understand that you have been trying for quite some time to get everyone together to meet with you and show you exactly what is compliant or non-compliant on your property, and you have had no success. She offered to bring all parties together on site such that we could have a meeting of the minds and come up with hard deadlines for me to achieve compliance. I responded 2 days later to that Monday email that she sent. My Friday email was to ask about what the repercussions of paying the fine was. On Monday, she responded twice to me with an offer to, tendered offer to become the person who would bring everyone together. That's officials from HAND, officials from Planning and Transportation, city legal representatives, and we would meet on my property, and she was willing to be the initiator of scheduling everyone, finding out when their availability was, and then offer me some prospective dates for that to take place. Well, on Wednesday, I responded, yes, let's do this. And I was excited because finally, for over a year, I have been asking for clarification. And as I say, emails, voicemails, certified letters, no one responds to me. Requests from to other city officials to be a mediator. You know, it's like when I come to City Hall, I feel like Moses parting the Red Sea. All the employees just flood from my presence.
Mr. Davis, if I may, Ms. Kate has come in, and I apologize. I understand you're bouncing between meetings, so I appreciate you stepping in. My question was, Mr. Davis referred to a 2-day email exchange. And the second day, he claims that you pulled back an offer, and I'm wondering if you can share with us the content of that message. Thank you.
I'm happy to, and I will say that I don't usually scurry when Mr. Davis comes to City Hall, as he knows I've met with him twice to talk with him here in the lobby at some length. But in terms of the emails, he reached out to me, and I'm just looking for the date. You may have already mentioned what the date of the
It was
original was.
October
but
2nd.
I just have to take a look. But basically, oh yeah.
At
that's
11:03
right.
in the morning, and again at 11:05
No,
in the
the-
morning.
Actually, the original email that I'm seeing was on the 29th of September.
That would be the email that I
About
sent to Ms.
fines.
Kate.
Yeah, that's right. And so he contacted me and said, to summarize, what if I pay the fines? Will this go away? I wrote back and he said, yeah, I'm really looking for a kind of a way to resolve this and to be productive moving forward. I emailed back and said, to clarify, no, paying a fine is not going to resolve this. Abatement is a separate remedy that the city is seeking, and that if you want to look for a positive way forward, I think we all do, and offered to have people meet with him to go through his property and identify if he needs additional guidance. And I sent that message, and then I immediately actually deleted it. So much for my Gmail skills. I thought I had actually deleted it. And I did that because I wanted to, as I told him later, I wanted to talk further with Hand and Planning, both about what had already happened by way of discussions about the materials on his property, but also because when I looked at it, I realized that it didn't talk specifically about this hearing, and I wanted to clarify that for this proceeding and also for the Board of Zoning Appeals, it's important for these to go forward. And so I didn't think that he had my message. I was talking with Hand and Planning. Then Mr. Davis emailed me, I think on the 2nd, as he said, saying, yes,
On the
I'd be
4th.
interesting. Excuse me?
On the 4th.
Oh, on the 4th, okay. Yeah, I'm not looking down at the dates, but he emailed me and said, yes, I'd like to go forward. I wrote back and said, thanks for your message. I was kind of surprised to see it because I didn't think I had actually sent my original one. I was working through some questions I had with Hand and Planning. But in any event, what I told you about fines still stands, and it's the same for planning. And these proceedings should go forward because you have had disagreements with staff, and we disagree about the level of guidance he's already gotten from staff about the materials on his property. And it would be beneficial for everyone to have this body and to have the Board of Zoning Appeals weigh in and provide guidance to Mr. Davis and to staff about what the status under Title VI and later under Title 20 is of the materials on his property and the methods he is using to store them. And so I said yes, and I made it abundantly clear. And then after I sent that message, I believe later that day, Mr. Davis came to City Hall, asked to meet with me. I went downstairs. We talked for, 20, 25 minutes. And I again made it very clear that this proceeding should go forward. That was our intent. It was going to go forward. Same with the Board of Zoning Appeals for the reasons I had said. And in my email and again when we met, I said, going forward and in the future, I still think it would be productive to have you bring your questions in good faith to members of staff. I also included the idea for talking with someone from the building department, which is not my idea, it's actually Mr. Wheeler's idea, and I think it's a really good one in terms of this issue of what kind of materials are building materials and what are not. And said, we're happy to continue those conversations in the future, but don't lose the opportunity for everyone to get clarification from these proceedings. That's what they are for. So that's the nature of the exchange. I'm happy to forward those emails. They may already be in your packet. I have no idea. Plenty of people have seen them, so they're there for you. And if you have any other questions, I'm happy to try to answer them in the next 5 minutes, and then I have to leave. So,
Any questions from the board? If you're fine. If you have a question.
Thanks, Ms. Kate, for the description. Could you tell me or us how the city could, I'm sorry, what would be the paper trail for the sort of agreement that's been discussed for
You may have to
visiting the
tell me a little bit
property?
more about what's been discussed, because I was not.
Yeah, so what
one for
I
this.
proposed was that before we would actually order an abatement on the property as we go through this evening, if the board takes action to deny the appeal and approve the abatement, which is one of the next items, that before we would actually contract with that abatement firm or have them go on site, we would do that meeting with Mr. Davis and the other parties to say, here are things that the building department and others would agree are building materials, here's what we definitely feel is garbage, and do that before the next meeting, or before we would actually order the abatement. I think Jane's trying to get at what would the paper trail of that be?
Well, yeah, and I'm hearing the phrase good faith and thinking about what it would mean for both parties to proceed in good faith. And I understand that there's a lot of history surrounding this relationship and the interactions, but I think that it would be better faith for the leverage to maybe not be there while the abatement is pursued in collaboration, but then to be able to consider this. So I guess that's why I was trying to get at what kind of contract or agreement would govern the way that you're discussing proceeding now, outside of the appeal or the NOV. What sets the terms of how you're going to discuss what gets thrown away, and how are you going to demonstrate your agreement so that Mr. Davis is clear on what is supposed to be removed from the property?
Let me clarify a couple of things.
Thanks.
The first is, I don't believe we would need a contract to memorialize the fact that the city is saying here in a recorded meeting that we would not send an abatement contractor out until there was a prior walkthrough with Mr. Davis. I think that's plenty of recordation about this. Secondly, ultimately, what determines whether Mr. Davis's materials are code compliant is the code and the people who are charged with enforcing the code's interpretation of that, and that includes you. Okay, it includes staff and it includes you, and if Mr. Davis disagrees with the decision of this body, it could include a court. He's been to court before, he could go again. There are standards for challenging that. But your question gave me a little bit of a red flag, because it made it sound like you think there has to be ultimately agreement before there can be any abatement. And while that is certainly the goal, I think that's everyone's goal, that's not guaranteed. And there has been a lot of disagreement in the past about these materials. And the city's enforcement of its code cannot ultimately depend on the acquiescence of someone who we believe is violating the code at the end of the day. So I think everyone in the city wants to try as hard as possible to come to some good faith resolution with Mr. Davis about the materials and the storage methods. But if that cannot be reached, I don't want this board to be left with the impression that in the absence of that, neither the city staff nor this board can act with respect to enforcement of Title VI, because that is not the case. Okay?
Thank you for that clarification.
You're very welcome. Thank you. All right.
Thank you for
I
joining
need,
us.
I need to make some points of clarification here
Okay.
regarding Ms. Kate's
Here's what
statements.
we're going to do for the remaining time of this item. You have 3 minutes to make additional comments. We do have to move on to other items. We have lots of people patiently waiting to talk about other things. So we're going to give 3 minutes for your information, and then the board will make a decision on how we're going to proceed with this item.
I'm sorry, I have not even been able to cross the statements that have been presented by Mr. Wheeler, Mr. Council, and Ms. Kate. This is my rights to due process are being denied, and 3 minutes is not long enough for me to present all of my information.
We have been discussing this now for 1 hour and at least 5 minutes. So I'm offering an additional 3 minutes at this time before the board makes its next decision on this item.
No, we have not discussed my offered exhibits. I have made no presentation. Yes, it is true that we have spent 1 hour and 5 minutes, but it's been all about the due process that I have not been afforded. It's all about the due process that is being denied me under my federal and state constitutional rights. It's improper for me to have to file lawsuits in circuit court just to achieve due process because as Ms. Kate just stated, the city has not been able to convey to me what is or is not compliant. The city just 2 business days ago presented me with information that Ms. Karen requested of them 8 to 10 months ago. And only now, and then Mr. Wheeler presents me with images that were taken today through trespass. All of these images were taken through trespass. None of the tenants at 528, 528 and a half, and 534 agreed to allow the city to come onto their property and snoop around. The tenants at 528 and a half, or 528, looked up their lease. There is nothing in their lease agreement that allows the city to come on without notice and snoop and invade my privacy at the same time invading their own by just showing up randomly. They have no business on there. It doesn't matter if the property owners have given them this permission. The lease holders have full rights of tenantship, full rights of property. They're paying to have full rights. It doesn't matter that they don't own it. If it's not written into the lease agreement that the city can come on wantonly and spy on me and persecute me just because it's in the best interest of the landlord, the non-occupying landlord, both of whom have been trying to get me off of my property that I purchased 14 years ago because it sat abandoned for 2 years. And they salivated and salivated over getting one more rental into their fold.
Okay, the 3 minutes have concluded. I appreciate your comments.
I move that we continue this appeal until the next Public Works meetings in 2 weeks. I have not been able to present any of my evidence. None of my evidence. You have not been able to receive my full complement of materials and images that I sent to April today. And this is supposed to be my
The 3
forum
minutes have concluded.
for
3 minutes have concluded.
presenting
Davis.
my facts
Mr. Davis.
to defend my rights.
Mr. Davis, I need to ask that you discontinue. Please adhere to the board, presiding officer of the board. Your time is up, as stated. This is now 1 hour and 13 minutes later. Ms. Deckard.
Okay. Are there any questions from the board at this time? Mr. Davis? Okay. Mr. Davis, I would like to ask you to have a seat at this time, please.
And
The time for this discussion has concluded.
so
Please adhere to the wishes of the presiding officer of this meeting. Mr. Davis,
Why-
she has asked for you to sit down. Can you please sit down?
why are my wishes to present my fullest case not being represented.
We have allocated over an hour and 15 minutes to this case. At this time, I need to ask that you have a seat so that the board can proceed with its business.
That is all the more reason that this
I call for
appeal
recess,
should
please.
be.
We're calling for recess.
Mr. Davis.
Resuming this meeting, this regular meeting of the Board of Public Works, this Tuesday, October 10th of 2023. We are returning from recess. Is the recording started? Okay, thank you. All of these things considered, I would like to make a motion that we move item number 1 under appeals, as well as item number 2 under Title VI abatement request for abatement at 1600, I'm sorry, item number 1 under abatement request for abatement at 530 South Washington to the end of the agenda after new business before staff reports. Is there a second?
Second.
All right, we have a motion and a second to move these items on the agenda. I will call the roll. Coopersmith?
Aye.
Carone?
Aye.
Cox-Deckard, aye. These items have been moved on the agenda. All right.
This be continued.
I have heard your request, and I appreciate it. I do need you to have a seat, please. Okay, next item on the agenda is petitions and remonstrances. This is an opportunity for members of the public to make public comment about items not on the agenda. I do want to emphasize that. We have several items on our agenda. This is an opportunity to make comments on anything that is not on the agenda. If someone would like to make a public comment about something not on the agenda, now is the opportunity to approach the podium. If you're in the room, if you're on Zoom, you can use the raised hand function or the chat function, and I will need you to state your name for the record. That's an excellent question. We'll get a copy of that for you. If anyone needs a copy of the agenda, we can get that to you. I think we have a couple other people who might want copies of the agenda. We may need to share, but okay, thank you. All right, please proceed with your comment.
My name's Mark Haggerty, and a few years ago, the city decided that the lot next to mine had too many weeds in it, and they decided they were going to clean it up with abatement, and they hired a private contractor to come in and have the homeowner, the lot owner, pay for it. We'd been trying to ask that that lot be used as a green space to barrier us between the 7-Eleven, which was on the other side of the lot there. And to that end, we'd planted a lot of fruit trees and berry bushes and things like that in between. Well, the fellow arrived with a bush hog and just started mowing down my wife's trees and her plants and everything that she'd planted. And she stood in front of that bush hog and wouldn't let him go. And pretty soon there were 6 police cars there, and they took her off to jail. I got home from work, and my son said they just took Mom to jail for protecting the lot over there. And I said, well, you're next, because I have to be on the phone. We didn't have mobile phones at that time. And they took her off to jail, and eventually the tractor driver said, I'm not going to have it. And he just stopped mowing. And we had 40 neighbors there. And the next day there was a picture in the paper with her in front of her little flowers there, having been released from jail. And we proceeded with this agreement that we could turn it into a green space, which we had already started on. But in the meantime, the city staff had decided that abatement was necessary without any kind of hearing or anything. So I have some concerns about civil rights of people and how things happen. I am particularly concerned about a candidate for mayor, the second candidate for mayor that's been eliminated from our ballot in a row. The first one was Amanda Barge, under circumstances that I've investigated and found to be corrupt, erroneous, a horrible mistake. And I don't want to see people being denied the ability to be on our ballot, because I don't think that this government is a popular government in this town, and I don't think that essential workers are represented well by it. I've been to circuit court last time during the early voting run-up when we had 4 hours, 4 blocks of people waiting to vote. And I went to circuit court and filed a complaint and asked that we open up another early voting poll. I was told that 4 hours is okay, and that the judge doesn't have the power to open it up, early voting polls like they do up in Indianapolis there too. So my whole general idea of this government is that it runs roughshod over anyone that opposes it. And that's why I'm here tonight, and that's what my concerns are. So I realize it's not quite on the agenda, but not quite off. Thank you.
Thank you. We appreciate your comments. Are there any comments on Zoom currently not related to items on the agenda?
I have a raised hand from Denise, and I will ask her to unmute.
All right.
Good evening. Can you hear me?
Yes.
I'm just wondering about the other 2 properties that are in the consideration for the new jail, the county jail. I know that.
Sure, we have your name on the record. If you could just state your name for us, that would be great.
Oh, sure thing. It's Denise Valkyrie.
Denise.
You're welcome. So I'm just wondering if the other 2 properties that are in consideration for the new county jail, which is desperately needed, have been considered to be assessed the same way that the Thompson property is being considered. I would like to see all 3 properties equally considered before a final decision is made.
Thank you for your comments. Other comments about items not on the agenda this evening? Yes, so the question was, is the obelisk issue on the agenda? And I believe that is in reference to item number 3, which is lane and sidewalk closure request from Reed & Sons for the Bloomington Gateway project at Miller Showers Park, and it is on the agenda. Thank you. All right, next public comment. And just so you know, we're observing the 3-minute public comment rule, so I just want to make that clear before.
I'd like to tell you about a past experience that I had with the city coming in and abating my property. This is unrelated to my appeal. This happened in the past. When the
Go ahead, you have 3 minutes.
When the abatement crew came in and the multiple civil standby officers were on my property in August, prior to the writing of this notice of violation on the 17th, then the abatement crew proceeded to be directed by members of HAND to take building materials off of the back of my truck, organized on the back of my truck. And then they proceeded to my trailer, my licensed trailer, and threw the tarp back and proceeded to go through and mine those materials. And it just so happened that Christopher Wheeler was there, and I was saying, these are my sanctioned building materials and tools. And Christopher Wheeler said, Joe, it doesn't matter. We're taking it all. It's garbage. And so the abatement crew were so able to recognize that these materials were not garbage that they said, no, these are not garbage, and they put them back. And then they took a few items that were maybe questionable, but then they were further directed by members of HAND to continue taking my things away. And I was able to provide my certificate of zoning compliance and my building permits. And Joe Stong of HAND, after she called and verified that, yes, I do have these items, then they stopped with the theft of my building materials. They stole overall around $2,000, I estimate, of building materials. And then when they stopped taking my building materials and busting up my 100-year-old salvaged garage, which you can't find anywhere, of great value, then they were told to take away my washing machine. And the third-party abatement guys said, no, this is not garbage. This washing machine is plumbed, it's electrified, we won't take it. And then, so in frustration, they proceeded up to the front of my house, and I had water catchment basins, and the third-party abatement guys helped me move those onto my front porch to protect them because they were standing up for me. They could see the injustice that was taking place. Thank you.
Thank you for your comments. Are there any other public comments about something not on the agenda this evening? And if you'll just state your name for our record.
My name is Jamie Scholl. I have a question about a definition in Title VI. We, in this community, reuse, recycle. These are things that I use to reuse and repurpose metal. It can be something purchased from the Habitat Restore, which is supported and by funding from City of Bloomington, Jack Hopton's grant. We have Discardia with the Center for Sustainable Living. So I wonder, as a business owner who's just getting started, if how we use our tools defines what is and is not garbage. I've been to Joe's place. I know that's on the agenda, but this has to do with anyone I work with. If I'm reusing materials, how am I to know, or anyone else a part of the community, what is defined as garbage? Because if we look at section 606020, and it's deposit of garbage, unlawful for any person to throw, place, or scatter any garbage, recyclable materials, or yard waste upon over any premises, street, alley, either public. We've all read that, I think, and are familiar with that. But when one person's found objects are being reused, or it's been given to them, who's to define what is and is not garbage? Because when I look it up, it's supposed to be food waste. Well, that would be composting. If I go to IDEM, is it waste? Well, waste is something that's discarded and no longer used. Well, if we're looking at a circular economy and to reuse things, whether it's discardia or something given, then how are we supposed to know what we consider is going to be reused and a supply for our next project, rather than putting it back in the waste stream? How are we going to know what is and is not? Because from what I've seen, things can be placed very carefully, and it would be an aesthetic issue. I've written something for the permaculture activist many years ago that talked about aesthetics and how local government can be used in different ways to define and reel in what is aesthetically pleasing to one and not another. So I'd like to bring that forward for consideration, and some clarity by this board and this administration would be very helpful. Thank you.
Thank you. We appreciate your comments. Any other public comment on items not on the agenda? No. Okay. Moving on, we are going to take up item number 2 on Title VI abatement request. This is request for abatement at 1600 West 3rd Street.
My name is Rebecca Davis, Neighborhood Compliance Officer, and I am requesting that you approve abatement of 1600 West 3rd Street. I started issuing notices of violation in June and all the way to September 21st, where I notified, sent a letter to notify that we were going to request an abatement of the property.
Thank you. Questions on this item?
I'm just wondering, this is the address on the NOV, it's an out-of-state address. Have you had any communication with the, looks like North Fork Holdings LLC?
So there have been several notices issued. I noticed today when I looked through the packet that the first fine that I gave them in June actually was paid. Since then, there hasn't been any indication that things have been received by them. I do know that the last notice of violation that cited that we were going to request an abatement was returned to us, at which point we looked for other addresses and attempted to send to a different address with this company, and that is currently out in the mail and has not been delivered yet. So we can't tell if it's been received or not at the new address that we used. But since I looked at the packet today and saw that the address that we were originally sending to, someone had paid, then I kind of feel like there has been potential communication there.
And just so I can confirm, it looks like the part of that original notice of violation on June 1 that was paid had to do with the overgrowth, and all of the subsequent NOVs are 606020 about the garbage and recyclable materials.
I believe that the first one notes both overgrowth and scattered garbage,
Okay,
I believe.
thank you.
Mm-hmm.
Any other questions on this item? Are there any public comments on this item?
There's nothing on Zoom.
Thank you. Is there a motion on this item?
I move that we approve the request for abatement at 1600 West 3rd Street.
And is there a second?
Second.
All right, we have a motion and a second. I will call the roll. Cooper Smith?
Aye.
Crone?
Aye.
Cox Deckard, aye. Motion passes. Next up is the consent agenda. Under the consent agenda is Resolution 2023-71, new mobile vendor, Planted Bloomington LLC. Resolution 2023-69, Bloomington Krampus Block Party. Resolution 2023-70, Fall Pop-Up Market. Outdoor lighting service agreement with Duke Energy for Wingfield Subdivision. Addendum to request for sidewalk and lane closures from Centerpoint on Kinzer Pike. Addendum to request for lane closures from Centerpoint on East 13th between North Dunn and North Walnut Grove, and approval of payroll. Do we have any items that need to be removed from the consent agenda this evening? Do we have any public comment on anything within the consent agenda?
I see nothing on Zoom.
Seeing none, is there a motion on the consent agenda?
I move that we approve the consent agenda for tonight's meeting of October 10th, 2023.
Do we have a second?
I second the motion.
All right, we have a motion and a second. I will call the roll. Cooper Smith?
Aye.
Corone?
Aye.
Cox Deckard, aye. Motion passes. Next, we have new business. First under new business is professional services agreement with Griffin Realty to assist with the public bidding process for the sale of the police building.
Good evening, folks. Adam Wason, Public Works Director. We're actually going to ask that this item be removed from tonight's agenda, and we can move on to item number 2.
Okay. We probably need a motion from the board for that item.
To remove it from the agenda.
I move that we remove item number 1, professional services agreement with Griffin Realty to assist with the public bidding process for the sale of the police building from tonight's agenda.
Do we have a second?
Second.
All right, we have a motion and a second. I will call the roll. Cooper Smith?
Aye.
Corone?
Aye.
Cox Deckard, aye. The item is removed from the agenda.
And if I could ask that the board actually move item number 3 to be the second item and number 2 to be the third item. I believe most of the public here tonight would like to speak about the third item, and we've been here for quite some time, so I think it would make good sense to move item number 3 to the next item on the agenda.
All right. I would like to do that. Should we do a motion for that?
Let's be official.
Okay. So I would make a motion to move the lane and sidewalk closure request from Reed and Sons for the Bloomington Gateway project at Miller Showers Park to item number 2. Is there a second?
Second.
All right, we have a motion and a second. I will call the roll. Cooper Smith?
Aye.
Corone?
Aye.
Cox Deckard, aye. Motion passes. We will take up item number 3. That is now item number 2 at this time. It's lane and sidewalk closure request from Reed and Sons for the Bloomington Gateway project at Miller Showers Park. This is for October 16th, 2023 through January 12th of 2024.
Yes, good evening, folks. Adam Wason, Public Works Director for the City of Bloomington. This item has been before you.
Sorry to interrupt you with the staff report. I think we have a question from the audience. I just want to make sure we offer clarity for this item. Yes. Number 1.
It is no
We
longer on the
removed it from
agenda.
the agenda, so it will be taken up at a later time. All right. Proceed with the staff report, please.
All right, let me find where I was at. Okay. So this is an item that has come before the board for the last several meetings. This is a request from Reed and Sons to use the public right-of-way for facilitating public improvements and other improvements within, or other projects within the Miller Showers Park area. The first permit consists of the work that will be completed by Reed and Sons, which involves several of the public improvements to the right-of-way. That include new ADA ramps, a new median in between College Avenue and Walnut Street, with improved turning radius, new sidewalks, new lighting features to improve visibility, new vegetation, including native trees and other improvements. And then the second permit consists of the installation of the gateway piece that would be done by BOMAR. So for the first permit is a road closure on North Old State Road 37 between North College Avenue and North Walnut Street for approximately 40 days. Some lane closures along North College Avenue for intermittent durations during the installation of the site infrastructure, sidewalk closures that connect to the median, lane closures that will allow for the milling and repaving, and then as well as that permit for BOMAR for a lane closure along in between College and Walnut Street on or around December 13th. Additionally, this does include the improvement we've spoken about before with the new portion of sidewalk on the west side of College Avenue, south of Old State Road 37 there, affectionately known as the Steak and Shake sidewalk that we've spoken about. And so this is to facilitate the installation of a gateway piece that has been contracted through the Parks Department and approved by the Board of Parks Commissioners for the installation of the gateway piece at Miller Showers Park. The board is being asked to approve the use of right-of-way for this, and we do request your approval. Happy to answer questions. We have staff here from multiple departments that can answer questions as well. So thank you.
Thank you very much. Questions from the board on this item? public comment on this item. Just a reminder, we're doing 3-minute comment at this time. And we will take comments both in person and on Zoom. I am going to start with in-person comments to keep things in order. And I do see we have several hands raised. I did see Ms. Zitlow. Yeah, please, if you can adjust that microphone, that would be great.
Can you hear me? Yes. Yeah, good. Thank you very much. You've been very patient, and I appreciate the way you've handled this so far. I'm here to speak against that installation of that thing that's proposed or have been built. I must say, I think this is a lesson in paying attention to what goes on in your organization, in committees like this. There's a lot going on that the public doesn't understand and doesn't pay attention to until the last minute. And probably it also has to do with lack of press coverage that we have grown into with these years, and that's unfortunate. But there was a really useful article in the Herald Times, I think it was the day before yesterday, that attempted to get some clarity as to what has happened. So at some point, money was approved, and a project was approved that the general public had no idea was happening. This phallic symbol that's being proposed for the entrance to the city with the picture Bloomington on it and colored lights comes as a great surprise to many of us, and an affront, I must say. Personally, I realize that there are different kinds of sensibilities to artistic things, but one of the things that Bloomington has treasured itself for, and wants to be known for, is being a city of arts and good, the arts. Let's say that. I don't recall, and nobody seems to know. Certainly, the people around here who are artists were not aware if there was any call for projects to be built with the millions of dollars that have been spent on this project. The project, the tower, or whatever we're calling it, was constructed, designed, and built in Indianapolis, giving no business to our artists here or artistic community here. And there was little awareness of it. And personally, I find it just plain ugly and affrontive, but I'm not the only one. And I think the unfortunate thing is that this seems late in the game, and I realize that the money that you're talking about here is for site preparation and getting the thing ready to go up so that we will be there. So, and I just think I understood that this includes the closure of Old 37, that would be the Cascades site. So now we understand why Cascades should be closed, to force the traffic up straight into Miller Showers Park and see this monstrosity. And that's unfortunate. So I'm here to oppose the construction and going forward with this. We have limestone here, which is a value that nobody else has in the world. Really good limestone for sculptures, and we have 2 sculptures now at the northern end of the Miller Showers Park that will be diminished. I don't know what they're going to be, how they're going to be handled, but they will be ignored, and there was no opportunity. Oh, I'm sorry, but I'm not trying to talk too much, but I did listen the whole time, the last hour and a half, politely.
Ma'am, I know
Thank
everyone
you.
knows you, but could you please state your name
Yes.
for the record?
Thanks.
Yes. Anyway, that's the problem with.
We appreciate your comments. Charlotte, would you be able to state your name for the record, please?
This is Charlotte Zitlow. I was at one time the president of the Board of Works, and I understand how hard it is.
Yes.
But in this case, I think that the public will be paying for something that they don't want and that they haven't been notified about. and that will not enhance our community in any way. And I do think that Bloomington, Minnesota has the Mall of America, and maybe they would welcome a gift.
Thank you for your comments. We appreciate them. All right. Other public comment in the room. I believe we had some. If you'll approach the microphone. I saw that hand first. And when you approach the microphone, if you could state your name for the record, please, and I'll set the timer.
My name is Susan Brackney. I hope that there's a way that you can grant permit number 1 and table or deny permit number 2. If the Bomar portion of this project had gone through all the proper channels and had adequate opportunity for public scrutiny, wouldn't its various legal, safety, environmental, and liability questions have been asked and answered long before now? If the illuminated tower contributes to human or traffic accidents, how will the problem be corrected? Is the city adequately protected, or do changes need to be made to any existing insurance policies to reduce its liability? Have necessary exemptions for this tower been written into the municipal code for outdoor lighting? If the illuminated tower significantly contributes to wildlife death or injury, what's the remedy? We know it isn't your job to answer these questions. We know. But you are in a position to serve the public interest and to protect the city by disallowing or indefinitely tabling permit number 2. Taking such action would not negatively reflect on any of you, personally, professionally, or as a board. We understand the position you're in. We know it's not your intention to act outside of your purview or to disrespect any of your colleagues in other departments.
Can I stop you for a moment? The conversation is very distracting. If you wouldn't mind taking it outside, please. Thank you. Please continue.
We're all here because due diligence may not have been done, and some important elements may have been missed. Now you are our first, last, and only fail-safe. I'd been trying to figure out what is it, and I figured it out. It's a fail-safe. You're an inadvertent fail-safe, but a fail-safe nonetheless. And I looked up the word because I thought, am I sure? Is that the word? Yes, it's the word. A system or plan that comes into operation in the event of something going wrong, or a system or plan that is there to prevent such an occurrence. I think some things could go badly wrong if this tower gets installed. In light of the serious questions around public safety, good environmental stewardship, and even potential liability for the city, I believe denying or tabling Bomar's permit request is the most responsible action that you guys could take. Thanks for the opportunity to comment.
Thank you very much.
Thank you. All right, and if you'll please state your name for our record.
My name is Betty Rosenagel. The first time that you all, 2 of you, dealt with this matter, I spoke on Zoom. And so the 3rd time that you're dealing with it, I wanted to come in person. I have many of the same objections to the process, to the aesthetics, and all the rest of it. But I'm going to ask you to think about it in a different way. Please save John Hamilton from making this mistake. He has a hard time, maybe we all do, I certainly do, admitting when we've made a goof, when we've messed up. Fess up when you mess up is a line in a song that I like a lot. But he has a hard time with it. So this thing goes up. A lot of people don't think it looks like much. And it's going to be, well, it's going to be his legacy. It's going to be part of his legacy. It's going to be a prominent part of his legacy. It's going to be welcome to Bloomington. So seriously, I mean this in good faith. This is a mistake. This is a mistake. It came about in a variety of 2018, something happened, and then there was a pandemic, and so forth and so on. But basically, as previous speakers have said, you are the last line. It is outside of your purview, but sometimes you need to step out and think outside of the box. And so please, for all of the considerations, the aesthetics and all the rest of it, save John Hamilton from this mistake. He has made a number of mistakes during his 2 terms, but you can save him from this one. Thank you.
Thank you. And if you'll please state your name.
My name is Valda Hillary, and I respect that this board didn't ask for all of this attention and that you were not involved in the earlier decisions about this project. And then, as everyone said, this is the last stop on the bus, so this is why we're taking the opportunity to talk to you now. As I and others have said on previous meetings, the plan is problematic in many ways. Put simply, it is an unsuitable location. It is an unsuitable representation of Bloomington and not created by local talent. It is unsuitable for wildlife. It is unsuitable use of funds given the many other pressures on our community right now. Much of the planning and input gathering for this happened during COVID times. I remember the survey. I took the survey. Never saw the results from the survey. So I want to give the benefit to the doubt to those who may have not have been as effective as they thought in trying to reach out to the public. COVID times were very weird, weren't they? I mean, really. And maybe we could use that as an opportunity to do a do-over, you know? Just because something was planned does not mean that it actually has to be completed. Just before coming down here, I read an article about Microsoft. They are withdrawing plans to change how they measure customers' file storage in the cloud and thus charge them for it. They got so much customer backlash that they are reversing course on the plan. If giant Microsoft can do that, little Bloomington can do that too. Thank you very much for your time.
Thank you. Other comments here in the room? And if you'll please state your name.
My name is Joe Davis, and I strongly encourage you to not approve the right-of-way work that will allow the phallic symbol to be placed in Bloomington. I myself have had phallic poking and prodding by John Hamilton round my behind, and sometimes penetrating my pocketbook, sometimes resulting in other penetrations, and I don't want to see the city of Bloomington to be so egregiously penetrated by this phallic monument to himself. It's unfair. It's a waste of money. Please do not approve the right-of-way improvements as they are written. We need more trees, that's for sure. We don't need any more trees taken down. This is a mess. Please do not approve it. Thank you.
Thank you. All right, do we have any other public comment here in the room? I see another approaching. And if you'll please state your name for our record.
Yes, my name is David Ebbinghaus, and I've addressed the board the past 2 meetings, and it's been very nice to hear everyone summarize all the arguments this evening. I don't think I can add anything that hasn't already been spoken. And we're not against the park, we're not against the park board, and we're not against infrastructure improvements. But since it's all been bundled together, where we can't cut the tower out of the plan and change the entrance from Gurley Pike, since it's all or nothing, I urge you to be the fail-safe. I know it's not your normal role to do that, but in this case, since this, in my opinion, it shouldn't have come this far. So because it has, you're stuck in an uncomfortable position of having to make a decision. And bundling it all together makes it difficult because there's a lot of this that's very, it's great. You know, if I were on the Parks Board and I would get 10% of my yearly budget handed to me if I would just let the tower be part of it, because they have an $11 million a year budget that was just approved, and they get $1.1 million from this bond issue. So if I were on the Parks Board, I would say, sure, you know, I would love to have you, you know, pay for the upkeep of the park. I don't have to find the budget for that. So it's very clever how it was all put together, and I have to admire that. But unfortunately, it goes against what I believe in, and that is that this is a bad idea. So I urge you to please deny the variances and go ahead and be the fail-safe against this project. Thank you.
Thank you. Any other public comment here in the room? I believe I see a couple. If you'll please state your name for the record.
Yeah, I'm Mark Riggins. I wasn't going to say anything, but, you know, I'm just encouraged by all the people that did. And the one thing I'd like to say is this: I just don't know how this got this far. I try and stay up with what's going on with the government and all the things, and this is incredible that I did not see this, and there's so many people in the community that did not see this coming until this article is showing the picture of it in the paper, and that's wrong. Whatever happened here, I think should be a lesson for us in the future so that it doesn't happen again. Thank you.
Thank you. Hello, and if you'll please state your name for the record.
I'm Jamie Scholl. In regards to this issue, I did read a number of comments from social media, Facebook, mostly Nextdoor at the last city council meeting, or 2 weeks ago. One of the things that I don't think many have thought about, if at all, has to do with safety in this. And given that my earliest, after I'm a bloomerang, so I have experiences in different parts of the country. And after leaving here in high school, moved to Miami, Florida, experienced close call of hurricanes, which I've done a few times, but then also moved to San Francisco and experienced a Loma Prieta earthquake, which influenced me in my perspective on food security and safety, which is usually what I'm known for. But in this regard, seeing the height of this thing and that it's metal, that I worry that if there is an earthquake, is this going to be safe? Are any of these that are planned going to be safe? And how far are they going to fall? Will they, you know, I'm pulled up on my phone the WTHR article, June 18, 2021, and there was a 3.8 magnitude earthquake that hit near Rockville. We're near the Wabash Valley seismic zone in southeastern Illinois and southwestern Indiana, and it's capable of a magnitude of 7.0 earthquake, according to USGS. Having been through and lived through a rebuild and, you know, the PTSD that followed and all of these different things, whenever I think of something this large, and if something should happen, should we not prepare for the worst? And has this, I don't know anything about the construction of, you know, we've all seen this, that's been published, but how is it being affixed, and is it going to be safe? Thank you.
Thank you. Any other public comments in the room at this time regarding this item? All right, I don't see any more in the room. I will turn now to Zoom.
I have
Are there some written comments?
several in chat.
Okay.
And one raised hand, so I'll read through the chat and then I'll have the raised hand.
Thank you.
Do you want me to read the names if I can?
That would be great, yeah.
Jane Goodman.
Speaking into the microphone, please, that would be helpful.
Is that better?
That is better, thank you.
Okay. Jane Goodman left a comment earlier saying she'd like to request that the monolith be erected at a different site and not at Miller Showers, which was designed as a native habitat. The presence of a tall lit metal monolith is inappropriate for this site. Name unknown on this one. I urge you to do what you can to stop this project until public opinion can be incorporated into the design. The current proposal does not represent Bloomington. It's not artistic or creative or quirky or even interesting. We can and should do better. Don't throw good money away after bad. Pileated states Bloomingtonians from many diverse backgrounds have come together to express strong objections to the monolith plan since it became public knowledge. Objections range from the likelihood of its killing large number of migrating birds to overwhelming feeling that this looming metallic design is aesthetically unacceptable, to a general sense that its designated funds could be used in a much better way for our community. I personally had seen no sentiments of support for this monolith from people who are not in the city administration. This statue is supposed to represent our community, and clearly it does the opposite. She continues to say, I'm sorry, this is a duplicate of the same comment. This is name unknown. Board of Public Works shouldn't have to deal with this monolith topic, deny or table all project plans, kick this back up to the city council to sort out which is the proper forum. This is from Shannon. Environmental study must be done on a giant lighted sign. Migrating birds are impacted negatively by light pollution. If Bloomington is to continue to pretend to care about the environment, this project needs to be canceled and the funds redirected to something that makes sense for the well-being of all. Andrea Kaiser says, I have also not heard any support of this installation and agree that it does not represent Bloomington. I personally believe funding could be used better. Pay the artist if it has already been created, work on improving the pedestrian opportunities and native landscaping. But I have heard no one express interest in this monolith, and I believe this aspect of the contract should be canceled/broken. Bloomington deserves better and could do better. Marilyn Bierman, I read the HT, the IDS, the Bloomingtonian, and B Square. I read. I listened to local radio, and until this came up recently, I had never seen an image of this thing or even heard it described. I am usually well informed. How was this plan not common knowledge? This is definitely not a gateway, does not fit the space due to size and scale, and it's certainly not a nod to our past per our mayor. I'm almost done with the chat.
That's fine, you're fine.
I apologize. I have additional comments from people who I've read comments from. Would you like me to read those or just?
Why don't we go to the individuals on?
Okay. Yep. So I have Denise, who has had a raised hand for quite some time. Denise, I'm going to ask you to unmute, and if you could state your comment.
Yes, this is Denise Valkyrie. For a lot of you know me, and some of our conversations I've said, and to you and to other people, and I'm sorry I'm a little nervous and tired, but a city planner's true value really isn't known for at least 100 or 150 years. And the public input methods that we have now are inadequate to really make legal notices. Readership in one newspaper has dropped so low that it's mostly online, and they've let go of most of their reporters. We do have several other news outlets that I do keep up with. I am equally surprised that I really had not heard very much about the monolith until recently. In our own neighborhoods, when we want to put up an art installation, it's an onerous process in which we literally need to go door to door and knock on everyone's door and leave them notification that we're planning an art project in our neighborhoods. We already have a monolith in Bloomington, Indiana on the IU campus that was built by the artist Rob Shakespeare, and it's in a place where They really do not want birds and wildlife right outside of the art museum. When traveling throughout the country, I've noticed when you come around the bend on US 31, I believe, into Birmingham, Alabama, you're met by a very large statue of an iron worker. In St. Louis, you're met by the arch. In Indianapolis, buildings to me represent our cornfields when they rise up off the flat plains. The arts and gardens in Indianapolis at the Art Museum and in New York City were designed by Olmsted and incorporate nature there. The area that we're talking about is supposed to be incorporating nature, and it's also a gateway to our city. Our city our gateway should reflect this city. We built the Empire State Building. We built the buildings in Washington, D.C. We've built the campus all out of limestone. And that gateway, if we're going to have something that represents our city in such a large fashion, should represent that, in my opinion. I don't think this is the correct artwork for the site. I think it has a negative impact on nature and the animals there. I do know that we do need more improvements and better traffic flow for all pedestrians, vehicles, and other forms of transportation. I don't think this is the last stop on this bus to stop this project. I think this is where we turn it around. I think you can be the brakes for this. I think contracts can be broken and renegotiated, and I think that our city needs to look into doing that post haste. Thank you.
Thank you. Are there other Zoom comments? I know you had mentioned there were maybe a couple additional comments by people who had commented earlier.
I have two more. This one is from Shannon. In case it's not known that migrating birds rely on dark skies to navigate, here's another comment to clarify that light pollution is really bad for migrating birds. See organizations such as Lights Out Indy. Diane says, we are limestone country. How rude to not use it as a Bloomington welcome. And that is it in chat.
All right. Thank you. Before we turn to board question and comment, as many people who made public comment alluded to, the Board of Public Works is here to consider the use of the right-of-way related to excavation activities, sidewalk reconstruction activities, and a right-of-way permit for the short-term use of a lane to install this item. So that is what is before the Board of Public Works. The Board of Parks Commissioners is the board that presides over the contracts for these items. They reviewed both contracts, contracts for the fabrication and design, contracts for, I guess 3 contracts all in all, contract for consultation, contract for fabrication, and then contract for the excavation and paving activities that were going to accompany this installation. And so they were the body that considered all of those items. So I just wanted to offer that context because the board's questions and the board's comments might be related to that context, not related necessarily to the other items affiliated with this project. So just wanted to clarify that if there's anyone who hasn't heard us clarify that in the past. I will open it now for board question/comment as we prepare for this item. I will just offer the comment, and this won't be the first time that I've said these things because we've had a few opportunities to consider this item. And first of all, I want to say and reiterate my appreciation to city staff who have worked really, really hard on this item. I have asked a lot of questions the board in general has asked a lot of questions, and the public has asked a lot of questions about this project. And city staff has worked very hard to get answers to those questions and to make those available. So I do want to thank city staff for their work. This item has been before us twice earlier. This is the third time that the item is coming before us. It does have some slight modifications to that, and that includes a permit that we are anticipating for the installation of the piece. So that was one change. As a member of the Board of Public Works, we, of course, in my statement, I clarified the purview of the Board of Public Works. We've had a lot of conversation about purview. I would say that moving forward on items of this nature, I would really like to see, when there are items that do involve the purview of the Board of Public Works, that those items be brought before the Board of Public Works, perhaps as a staff report or as some other form of update, even if we're not the signatories on a contract. Just for a little bit of context, the Board of Public Works, when we receive engineering contracts, we typically are reviewing the engineering contract, and we often are also reviewing the transportation plans around that project. And if not in that same time, we might be reviewing those at a later time, but engineering has crafted a timeline for us in most cases. And so we can see the items and the pattern that they are going to come before us. This item, it's been reported, has been an item that has been in progress for approximately 5 years. We have this item before us now, but the Board of Public Works was not a part of this process until this item is coming before us in the last few weeks. So while there have been different, both lengthened and expedited timelines related to this project, the board has taken this opportunity to review these things. And I think that it would be helpful for items like this when there is both right-of-way usage and also engineering work related to the right-of-way, helpful for the board to have that information when the contract is being reviewed. Because this situation can arise where there is a bit of a tension and a conflict between a contract that has been authorized and the access to the right-of-way. I would also say that within the board's purview, we authorized a contract with a consultant, Tool, who is reviewing the College and Walnut corridor. And that has actually been the root of many of my concerns about this project, because this particular crossover point was pointed out by Tool when they gave the presentation to the public in the summer, of an area of opportunity for reconstruction depending on how that corridor would be modified. Now, we are still very early in that corridor process. We have spent almost a year with Tool Consulting, and also have a resident committee that is dedicated to reviewing that corridor. And all of that work is happening in conjunction between planning and transportation, with engineering support, and also with Board of Public Works support and Board of Public Works signatory on that agreement. There has been some effort to do some level of coordination, but the coordination has not fully taken place between the residential committee and the review of this particular project, in part because the timing is a little bit off for those two things to happen. So the residential committee is still reviewing the corridor and making some suggestions about the corridor. So what we have right now is a situation where timing has been a challenge. And some of these issues have been at the core of the concerns that I have had, especially as it relates to the residential input and feedback related to the corridor study in direct connection with the item that is within our purview, which is the request for right-of-way use and reconstruction of the right-of-way in that area. So I just wanted to offer that clarification. I think these questions have bubbled up over the course of the last couple weeks, but it has been important to me to just be able to offer that context as to where my line of thought has been in considering this item. So I appreciate all of you taking the time to listen to my comments on this item, and I will look to the board to see if we have a motion on this item.
I move that we approve the lane and sidewalk closure request from Reed and Sons for the Bloomington Gateway project at Miller Showers Park from October 16, 2023 to January 12, 2024.
We have a motion. Do we have a second? We do not have a second at this time. Motion fails. All right, we'll move on to our next item, which is sidewalk closure request from Michaelis Corp. On South Walnut Street and East Smith Avenue, approximately 4 months.
Hi, Maria McCormick from City Engineering. This is a request from Michaelis Corp. I can never say it right. They are working on the urban station building, which holds the chocolate mousse. The brick facade is failing and they need to replace it. They are requesting to have protected sidewalk closures along Walnut and Smith Avenue, as well as close the north-south alleyway behind the building, which actually is in between the two urban station buildings. They have coordinated with both the Chocolate Mousse and the Project School. Hopefully you guys got the letter in your packet from the Project School. And you have their request before you.
Thank you. Questions from the board on this item?
No questions.
I'll just offer a recap from the work session that we discussed the fact that there is a fall break being observed by the project school at this time, this week and next week, and that we certainly encourage any work that can be done during these break times to proceed. We appreciate the petitioner's efforts to remedy this situation as quickly, and of course appreciate your department's participation in helping them to remedy this situation quickly. Yes. So appreciate that. Do we have any public comments on this item? Okay, seeing none, is there a motion?
I move that we approve the sidewalk closure request from Michaelis Corporation on South Walnut Street and East Smith Avenue for approximately 4 months.
Second.
All right, we have a motion and a second. I will call the roll. Cooper Smith?
Aye.
Carone?
Aye.
Cox Deckard, aye. Motion passes.
Thank you.
Thank you. Next up, we have contract with Ancris LLC for kitchen renovations at Fire Station Number 2.
Public Works Director. As you mentioned, this is for a kitchen renovation at Fire Station Number 2. And I need to find that part of my packet. Does anybody have a page number?
Oh, I
No.
should be there. It's, I think it's 164.
All right.
That's mine, at least.
So we had, did have a base and a total quote, the base quote, and then a ceramic tile flooring alternative. This is, Anchorage came in at $64,975. Fox Construction came in at $71,775. And we do recommend and ask for your approval with Anchorage for the amount of $64,475 for the fire station number 2 kitchen renovation work.
Thank you. Questions on this item?
Just to note that I will recuse myself from this item and the next. Thank you.
Thank you. All right. Any public comment on this item?
Zoom.
Okay. Thank you. Do we have a motion on this item?
I move to approve the contract with Ann Chris LLC for kitchen renovations at Fire Station Number 2.
And I second. We have a motion and a second, so I will call the roll. Cooper Smith?
Aye.
Carone is an abstention, recusal. Cox Deckard, aye. Motion passes 2 to 1 recusal. Next item on the agenda is contract with Ancris LLC for restorative roof coating at Fire Station Number 2.
Again, Adam Wason on behalf of J.D. Boroff, our facilities director. So the surface on metal roof at Fire Station Number 2 is deteriorating. The powder coating on the surface has been coming off. We took in 2 bids for this project. Tried to solicit 3 different contractors, only 2 put in. Ancris came in at $138,000. B&L Sheet Metal and Roofing came in at $161,900. We ask that you award this to the lower bid with Ancris LLC in the amount of $138,000.
Thank you. Questions from the board on this item? Okay. Any public comment on this item?
I have nothing on Zoom.
All right. Seeing none, is there a motion on this item?
I move to approve the contract with Ann Chris LLC for restorative roof coating at Fire Station Number 2.
Nice second. We have a motion and a second. I will call the roll. Cooper Smith?
Aye.
Carone is a recusal. Cox Deckard, aye. Motion passes 2 to 1 recusal. Contract with Heflin Industries, Inc. for installation of exhaust hood at Fleet Maintenance Garage.
Again, Adam Wason. So this is a project at the request of the staff at the Fleet Maintenance Division for a hood to be installed over a welding area. It's a 4x8 hood. 3 quotes were solicited. Heflin came in as the low quote at $8,887, and we do ask that you approve that contract.
Thank you. Questions on this item? Any public comment on this item? Okay.
I have nothing on Zoom.
Seeing none, is there a motion on this item?
I move that we approve the contract with Heflin Industries, Inc. for installation of the exhaust hood at the Fleet Maintenance Garage.
Second.
All right, we have a motion and a second. I will call the roll. Cooper Smith?
Aye.
Crone?
Aye.
Cox Deckard? Aye. Motion passes. All right, we're now bringing back forward the item number 1 under appeals, appeal notice of violation 62038-08-1314. This is at 530 South Washington.
Can I actually, President, ask for a brief recess? My blood sugar's getting low, and I just need to run out to the car and get a snack.
We will call a recess. All right, I am bringing us back from recess to this regular meeting of the Board of Public Works this Tuesday, October 10th of 2023. The item that I brought forward right before we went to recess was appeal notice of violation 62038-08-1314 for 530 South Washington. The other item still on our agenda was request for abatement at 530 South Washington. First, I want to just offer some comment, and then I'm going to offer a motion for consideration by the board. Just want to be clear. My desire this evening is to table this item for the next meeting of the Board of Public Works, which I believe is October 26th. Can we check that? October 24th. Okay, I want to be very clear for the public. There are people who might want to make public comment at that time. Just before I make that motion, I do want to clarify very clearly that when these items are brought back, the items that the board receives in its packet are the items that we receive in our packet. We will not be adding items. Typically, our packets are completed by Thursday. Yeah, Friday before the meeting. So I just want to be clear on the content of our packets are what they are when they come before us. We will not be looking for any adjustments to the contents of the packets unless it is requested by the board.
May I add context?
Sure.
That might be useful. I know you know this,
Yeah.
but this is the 48-hour requirement by the open door law that we follow, I believe. Adam's going to say, no, you're wrong, Jane.
We have a very specific process for putting items into the board packet. They come from staff, and in most all circumstances, the items that are brought before, if there's anything that the appellants or anyone wants distributed to the board, we do that on a regular basis. We give you all the information as the board to provide you, and as we did in the case this evening. Other good examples of this, and I'm going to go back to, on the Gateway project that we took up tonight, there were a lot of requests to put this in the packet. I want you to put this into the packet on behalf of me as a public citizen. The packet is the information that the board's to consider. That's what the public comment period is for. That is where we make email addresses available to the public for submitting information to Public Works that then can be submitted to the board. We had folks that wanted your personal cell phones yesterday to be able to provide information to the board. That's not how it works, plain and simple. It's we work with staff and others to put together the packet of information for the board. Anyone that wants to provide further information to the board gets that. I think you would all attest. You got a lot of emails today. You got a lot of information coming in. We will always provide that information, but it will not go in the official packet of the Board of Public Works.
Correct. So I want to be clear about that. Thank you for summarizing that, because that is 100% true. We have received many emails today and in the days leading up related to many items in our packet this evening. So we do receive that public feedback, and of course we hold this forum so that the public can be engaged and involved and make their comments, as well as in the case of an appeal, the appellant has the opportunity to bring forward their appeal. Now, expectations for that appeal. There are not any expectations that the board or the staff of the city will provide technology to display items. I actually prefer that we don't have items up on the screen for display. I would prefer that the board hears the appeal and considers what has been written in the appeal as well as the verbal appeal. So I just want to be very clear that when we come back on October 24th, the staff and the board will not be asked to provide a certain level of technology to support a presentation related to the appeal. And in fact, we really don't use that technology for any presentation, period. So I just want to clarify that, partially because we tend to not use technology for our other items. Also clarify because there could be technological failure or other things that could cause disruption. We have too many things happening in the technological sphere to guarantee that we would be able to offer that, and that does not preclude the appeal process from being conducted. So want to be very, very clear about that. So the expectation would be that when we hear appeals, that we will have the materials in our packet. We will receive any feedback that's coming in from the public leading up to the meeting. Also being practical, board members travel from some point in the city to the location of the meeting. If something comes in after 5 p.m. or even maybe at 4:30, the likelihood that the board is going to see that item before we start our meeting is slim. So just want to be very clear about that as well. There are just practical time constraints. that we deal with. And that is going to be a factor when we are making these considerations. When we conduct the appeal, the presiding officer presides over that process. So we open it up for the appellant to speak. We hear from our staff representative of the item. The board gets to ask questions, and in the case of appeals, we do not open it to public comment. In the case of abatement, we do open it to public comment. The reason is because the appeal is the opportunity for the appellant and the city to present their case. So want to be very clear about the expectations on that as well. Is there anything that I have left out that needs to be clarified as we prepare for our October 24th meeting?
No, I think it would benefit everyone that as we lead into that, we're going to do what we've said. We're going to try to meet with Mr. Davis and really try to discern some of these things. There, as Corporation Counsel Kate said, there's been disagreement about that the entire time this has been going on. So, but we will, in a good faith effort, to continue to try to do that. I think it would be helpful probably for the appellant to know a amount of time he has for his appeal, so we can discuss that and make sure he'll be well aware of that leading in, whether it's 15, 20 minutes, however you want to talk about that. And we'll make sure we're in good communication with Mr. Davis, as we always try to be. So.
Okay. I'm glad that you mentioned that. I think that it makes sense. Just based on what we typically would hear for appeals, that we allocate 15 minutes to the appellant and 15 minutes to city staff. So we can anticipate a overall time of 30 minutes with 15 minutes to the appellant and 15 minutes to staff. We will allow for time for board questions, which if history is any indicator, typically does not exceed the 15 minutes as well. So we can, I think, expect that unless it seems like we need to make adjustments on that.
I have one additional request, that if there is material from either city staff or the appellant pertaining to this case prior to the 24th, that it be shared no later than 24 hours before our meeting. We all have full-time jobs and are not able to give the information that's shared with us that day, particularly at 4 o'clock that afternoon, the importance it needs. And I would request at least a 24-hour window ahead of time for materials to be shared specific to this case.
It'll be our intent to make sure all materials are shared by noon on the Friday before when we do publish.
That would be great. Thank you very much.
All right. With that, I am going to make a motion to table the appeal notice of violation 62038-08-1314 for 530 South Washington to be taken up again at our board meeting on October 24th.
Second.
All right, we have a motion and a second. I will call the roll. Coopersmith?
Aye.
Carone?
Aye.
Cox-Deckard, aye. Motion passes. In alignment with the next item on our agenda is under Title VI abatement request. I would like to make a motion that we table the request for abatement at 530 South Washington to our next meeting on October 24th.
Second.
All right, we have a motion and a second. I will call the roll. Coopersmith?
Aye.
Carone?
Aye.
Point of order,
yes,
Madam Chair.
yes.
I do believe you should probably offer public comment since there is a motion for the table.
For the tabling. All right, I will call public comment for that motion. And if you'll state your name.
My name is Joe Davis.
Oh, sorry, we turned it off during recess. Just one moment.
My name is Joe Davis, appellant, and I would like to ask that there be a court reporter present such that there'll be a transcription available should I need to take this to the circuit court on appeal if things don't go the way I wish them to go. Also, I request that there be an opportunity to cross any witnesses from the city of Bloomington following their comments This is normal in a court of law, and it's part of due process. Thank you.
Thank you.
I have a question, though. With regards to the abatement, if I may.
Yeah.
You mentioned that on the appeal side, you would prefer to have any new items presented to the board 24 hours before the meeting. With the abatement, however, it has been the board's practice in the past to always ask staff, what's the condition of the property on the day of the abatement? And so I would like some instruction on whether the staff should take photographs of the condition of the property and present them on the day of the meeting.
We will confirm that with you over the course of the next few days.
I'd appreciate that. Thank you.
Thank you.
That'd be great. Thank you. All right.
And I ask that you also confirm that with me as well over the next few days. Thank you.
Thank you for your comments. We have another public comment. If you'll just state your name.
Thank you. Jamie Scholl. I prepared this to read. It's kind of a email letter, so to whom it may concern, all here. That Joe Davis, who was a leader and educator in natural building practices and spent countless numbers of hours dedicated to serving this community, has these charges against him seem an affront and in contrast to the words this administration states to support in regards to sustainable practices. I have known Joe since 2003 through the Natural Building Group housed under the Center for Sustainable Living. Joe actually taught my now former partner and I how to build a straw bale house. He even taught some with my daughter, who was quite young at the time, and she now knows how to do natural building. Joe is an excellent teacher. I have visited Joe's property on a number of occasions and reviewed the city code as well as item definition of garbage and waste. Waste includes, in this definition in Title VI of the Municipal Code, unwanted building debris from construction and demolition project. Given Joe's dedication to sustainable practices, keeping items out of the landfill and refurbishing and reuse is part and parcel of the actions behind the flat words on paper that make up sustainability. Community members designed and supported Discardia, its annual fashion show, and the Habitat for Humanity Restored. It's supported through Jack Hopkins grant funding. Our own support for the circular economy is alive and well and supported, so the abatement of building materials to be reused by a respected member of this community is perplexing. According to Section 606.20 deposit of garbage, and this is where I brought up earlier, what is garbage? And that was, I heard you, Mr. Wason, mention the garbage, and then I heard Miss Kate called it materials. And then to determine what are the materials that could be used safely. I have seen how Joe is repurposing building materials. He has them stacked and organized with a plan of use. The photos that you presented, I've seen those. Some of the things noted, I cannot agree with. Having locally given introduction to permaculture presentations since 2009, I see that Joe's plans are sound and move at a natural rate, which is in alignment with how implementation of permaculture design principles are approached. I myself and many others in Bloomington have recovered materials for reuse and construction. Perhaps the way some materials are used or displayed or arranged are not in alignment with the prevailing aesthetic sensibilities. However, I do not in any way see that they are in violation of city code. It appears that the system meant to keep residents of the city safe are being used in a manner to unfairly target Joe Davis. The refurbishing and reuse of building materials is in support of a sustainable city through the reduction of greenhouse gas emissions. If this really is a goal of the city, then the administration should be supporting and working with Joe. Thank you.
Thank you very much. Are there any public comments on Zoom?
There is no comment on Zoom.
All right. Just want to offer clarifying comment that there will not be a court reporter present and there will not be cross-examination. This is not a court of law. This is a city public meeting, and the documentation for the city public meeting is conducted by its minutes, as well as in this case, because we're using technology with Zoom, we are also recording that, as is our wonderful resource, CATS, recording the meeting. as it would be. So that would be the recording of the meeting properly, and we will hold that meeting to the same standard as our other meetings. All right. So we were voting. We had a motion and a second. I will call the roll. Coopersmith? Aye. Carone?
Aye.
Cox-Deckard, aye. The item has been tabled for our next meeting. Thank you. Next up is staff reports and other business.
No staff reports this evening.
Thank you. Next up is approval of claims. Are there any questions on the claims? All right. Any public comment on claims?
There is nothing on Zoom.
Is there a motion on claims?
I move that we approve claims tonight in the amount of $1,921,311.25.
I second the motion.
All right, we have a motion and a second. I will call the roll. Coopersmith?
Aye.
Carone?
Aye.
Cox-Deckard, aye. Motion passes. And with that, if there's nothing else, I will call for adjournment.